The unusual thing about this case is that it concerned only a small, narrowly defined cohort of students who had qualified for ILR and would have had ILR but for the suspension of this priority service. By its very nature, the situation is unlikely to reoccur. The super priority service has been reinstated. So the claimants in this case successfully argued that they had been unlawfully discriminated against and that Article 2 of Protocol 1, read with Article 14 of the ECHR, had been breached. So this is an important case in the area of student finance and human rights and should be read alongside the existing Supreme Court cases of Kabidi and Tegere. And on appeal to the upper tribunal, the local authority argued that the FTT had no jurisdiction to require a local authority to exercise its discretionary power under Section 46 in favour of an extension. And so the FTT's error was not material, but the upper tribunal accepted that the FTT lacks the power to compel the local authority to exercise its Section 46 power, but made it clear that the possibility of a Section 46 extension remains something that the FTT can take into account in deciding what provision to offer. So important in cases concerning young people who are on the cusp of turning 25. The parents said they would transport the child to School 1 themselves. The Welsh Tribunal dismissed their appeal on the basis that the proposal to transport the child was voluntary and could end at any time, leaving the local authority with a statutory duty to arrange school transport. The upper tribunal, however, allowed the appeal, holding that the tribunal had overlooked the possibility of naming more than one school in Part 4, naming one school as a primary placement, subject to a condition that the parents arrange transport at their own expense. So a Welsh decision, but interesting on the vexed and increasingly common issue of transportation being the defining issue between two schools, one in particular that parents may want